Assistant Public Defender Chinazi Carey Akinruli, Your Honor, on behalf of Mr. Dion Baldwin.
Your name, sir?
Mr. Dion Baldwin.
Thank you, sir.
How are you doing today?
This opening may sound casual on the surface, but it immediately sets the tone for what kind of courtroom we're in and what kind of judge we're dealing with. Judge Simpson, male, conversational but alert, uses light banter to establish control while signaling that this court is very much paying attention. This is not filler. Early exchanges like this matter because they humanize the defendant while simultaneously reminding everyone that this is a serious legal proceeding. We're dealing with a home invasion allegation. Family conflict, probate issues, and bond restrictions all colliding in one hearing. Right from the jump, defense counsel flags that this case is complicated, which in courtroom language usually means overlapping legal systems, criminal court versus probate court, and conflicting narratives about ownership, access, and intent. The defense is already laying groundwork. This isn't just a crime scene, it's a family dispute that escalated. That framing is critical because it directly impacts bond, credibility, and potential mitigation later. The hook here is clear. Was this a criminal invasion or a family member asserting a misguided claim to property he believed was his? And more importantly, does belief matter when violence and threats are alleged? Keep that question in mind because everything that follows hinges on it.
I'm doing great. Yourself?
I'm trying to be better.
Okay.
Yeah.
Aren't we all, though?
Yes, sir.
Your Honor, we are asking.
Some of us. Here comes Akinruli. We're going, no.
We're asking for an adjournment in this matter, Judge. I've had an opportunity to speak with Mr. Baldwin. There's a lot to this case. We're unpacking all of the pieces to see a way forward. So we need time to continue to discuss. And I would also like to address bond.
Probable cause conference, December 23rd, 2025, 9 a.m. All right. As to bond, Judge,
Mr. Baldwin is asking that the court consider reducing his bond to an amount that he would be able to pay. I think initially he was asking if there was a temporary release of some sort that he would be able to do. I think that there's some money issues that he needs to sort out. He's got a P.O. box that he needs to attend to. He does not have much family support, and he's pretty much on his own. So since he's been in custody, there have been a lot of his personal effects and matters that have gone unattended to. He indicates that he does have some finances, but a lot of that is tied up right now, and he's unable to access it. He's hoping that if the court would consider releasing him for a few days, he would be able to sort that out.
This is a classic bond argument, and it's worth slowing down to understand what's really being asked here. The defense isn't denying the seriousness of the charge. Instead, they're reframing the defendant as overwhelmed rather than dangerous. Notice the strategy. No family support, finances tied up, personal affairs unattended, and a claim that temporary freedom would allow him to stabilize his life. In theory, bond exists to ensure court appearance and community safety, not to punish. But here's the tension. Judge Simpson must weigh sympathy against risk. The moment the phrase home invasion enters the record, the burden shifts heavily against release. The defense tries to soften that by introducing probate issues, suggesting a legitimate ownership dispute. But intent matters less than conduct at this stage. Even if Mr. Baldwin believed he had rights, the court is asking, did he act in a way that endangered someone? Audience question, if you truly believed a house was yours, does that justify showing up with a knife? Or does the law expect disputes to be handled only through courts, not confrontation? This is where legal theory meets human emotion, and judges live in that uncomfortable middle ground.
This is a home invasion case. However, Your Honor, one of the questions that needs to be determined is the owner of the home. It's a family property, is what he indicated to me. It's a home that was owned by his mother before she passed away. The complaining witness in this matter is a family member. So right now, there's some type of dispute as to ownership and who has rights to the home and things of that nature. That he indicated to me that he plans to file something with the circuit court, specifically the probate court, to see if he could become the personal representative of the home. Those are some of the things that he needs to sort out, Judge.
Is that the nature of this case?
That's one way.
Yeah.
Okay.
The other way of looking at this, the facts involved, I will acknowledge the victim, I believe, is a cousin of the defendant, but found the defendant in her home. She was chased from her home with the defendant because he was wielding a knife and was demanding that this was basically his house now when she has lived in the home. And I would very much disagree with the assessment of the defendant's claimed ownership of the home. I believe that the same incident effectively happened the day before, the day or two before this incident, and he was advised by Ann Arbor police to stay away. In that incident, charges weren't filed. He was just hanging out, maybe attempting to entry, and he went back the very next day, same thing, and which led to these charges. The statements made by Ms. Akira Ruli, there may be some ownership dispute down the road, but at the time this event took place, we have no reason to believe the defendant had any ownership of the home. My concern is that the defendant was effectively told by Ann Arbor police to stay away, and he went back the very next day, leading to these charges.
But, yeah, right. But, God, I don't want to get into this, but the mom passes away. There is there's a collateral heir that is residing with mom, being the cousin.
She wasn't residing with mom, but his brother actually right now was personal representative of the estate. I looked all through the probate document.
Hold on, say that again.
His older brother.
His older brother
Correct.
is the executor of the estate.
That is correct right now. Technically, but I mean, that's what.
Well, then that means that individual has control over the property at this point.
This is one of the most important legal moments in the entire segment. Judge Simpson cuts through the emotional fog and anchors the decision in black-letter law. Probate law is brutally simple here. Until a court says otherwise, the personal representative controls the property, not the cousin, not the sibling with the loudest voice, not the person who feels wronged. This distinction destroys the defense's implied justification. Even if Mr. Baldwin may eventually inherit or assert an interest, that future possibility does not create present authority. Judges are particularly sensitive to defendants who try to self-enforce perceived rights, especially with alleged weapons involved. The judge's concern isn't abstract, it's behavioral. Being told to stay away and returning anyway is a massive red flag. From a public safety standpoint, that behavior suggests defiance of authority. Ask yourself, if the court ignored that pattern and something worse happened, who would bear responsibility? That's the silent pressure judges carry. This moment also shows why civil remedies exist, to prevent exactly this kind of escalation. The law does not reward impatience, anger, or entitlement.
Which means it's not his. He may have an interest in the property ultimately, but it's not his property.
Right. One of the things that he wants to do is to file whatever necessary documents with the probate court to challenge that.
Okay, but the problem is you can't, even if that were the case, you can't go and chase people, at least allegedly, away with knives and other things from the property, indicating that it's his. And that's the part that concerns me. So if he were released, where would he reside?
He does have his own place, Your Honor. He has that's the International Drive address, is what he indicates to me, Judge.
Current.
Okay. Before I would even consider changing his bond, I would need a verification that that is his address.
Okay.
And I would sign an order releasing him actually on a PR, but home confinement to that address.
Okay.
Here's where Judge Simpson demonstrates measured restraint. He doesn't outright deny the possibility of release, but he raises the bar significantly. Verification of residence, tether, home confinement, these are not favors, they're safeguards. This tells us the court sees risk but is still operating within due process. Judges often leave the door slightly open to test compliance, but make no mistake, this is a warning phase. Any failure here would almost certainly harden the court's stance going forward. This also highlights how bond decisions are not just about money, they're about structure. Without structure, release becomes chaos. Audience engagement moment. Do you think courts should ever allow temporary release in cases involving alleged violence if strict monitoring is imposed? Or is jail the only safe option? This balancing act is why bond hearings are some of the most consequential yet misunderstood parts of the criminal process. They quietly shape everything that comes next.
Obviously, that's assuming tether.
Yes, with a tether home confinement to that address.
Okay.
But I'm not going to order that right now because I'll need the verification. Council understands what I will order. And then they prepare an order to the court regarding that. All right. At this point, this bond will continue. New date is December 25th. 9 a.m. Jackson.
Judge. Portia Feaster, Assistant Public Defender, on behalf of Mr. Javante Jackson, come to the podium. Mr. Jackson, when you arrive, please state your name for the record.
Javante Jackson.
Thank you.
Thank you, Judge. I did speak to Ms. Zinda on this matter. I know she has something she's gonna be requesting. I also met with Mr. Jackson in custody on Tuesday. We are going to be requesting an adjournment to try to get some new information discovered that Ms. Zinda is going to talk to you about here momentarily, Judge.
All right. Yes.
If I could address bond, came to my attention that Mr. Jackson has called the victim. There were 3 complete calls that were just about a minute long. In those calls, the victim calls him by his nickname that she referred to him in speaking with her brother, who's also in custody previously, and is immediately upset that he's calling her, tells him to stop calling her. And then after those calls are complete, he has about 180 attempts to call her that she does not pick up. So at this point, I'm going to ask that his phone privileges be revoked, and we will be blocking her number from the jail, given that he's tried to call her 180 times. And all of that is in violation of the probation that he's on, the 14B, with the domestic violence second offense case that he had with her. So I have concerns that he's still violating both the PTO and his probation concerns at this time.
I was made aware of that this morning, Judge. I haven't spoken to my client about it. Obviously, I'll reserve comment until I receive phone calls from Ms. Zinda, but I understand what the court's likely to do.
When he's on probation, in case involving her, which would contact would be prohibited. Contact is prohibited in this case.
And there is a PTO.
And in listening to at least the portion of those calls, there's an indication that the victim has said that to stop contact.
In pretty much all of those calls.
That from this court standpoint seems rather egregious in terms of behavior. Certainly he would be entitled to a hearing on it. But at this time, there's going to be I don't think he can behave himself if he ever got out. So not only are his phone privileges hereby ordered revoked, the defendant's bond is also revoked at this time.
This section is a stark contrast to the earlier discretion shown. Judge Simpson's tone hardens, and for good reason. Violating a no-contact order isn't a technical mistake. It's a direct challenge to the authority of the court and the safety of the victim. 180 attempted calls isn't accidental, it's obsessive. This is why judges treat protective orders as sacred. They exist because past behavior has already crossed a line. When a defendant ignores those boundaries, credibility collapses instantly. From a legal standpoint, bond revocation here is almost automatic. The court is no longer asking, will he appear, but can he control himself? And the answer, based on evidence, is no. Engagement question: should repeated phone contact alone be enough to revoke bond, or should courts require an in-person violation? Most judges will tell you the danger often starts long before physical contact resumes. This ruling reinforces that preventative justice is still justice.
Thank you, Judge. I'll get a copy of those calls from Ms. Zinda, and I'll take them over for my client to listen to.
Your Honor, what was the due date? I apologize.
What date did I say? I didn't.
You didn't yet.
The 23rd.
Okay. Thank you, Judge.
Court calls the case People versus Daniel Cummings.
Assistant Public Defender Sandra White on behalf of Daniel Cummings. Can you state your name, please?
Daniel Cummings.
Your Honor, we're going to ask for an adjournment so that I can have more time to speak with Mr. Cummings and the prosecutor. Mr. Cummings is asking for an adjournment about a month out. He has different procedures coming up and he wants to get all of his dates together.
You've seen his test result? Apparently not.
Yes, we discussed.
From the 24th?
Just a second, Your Honor.
Council approach.
Yes, but I'm trying to hear this is treatment.
You might want to get that button.
Your Honor, can we get an adjournment for about a week so I can?
Yes, and just so that we know that on the 24th of November, defendant tested, which is actually only tested, he's taken a tested positive for fentanyl in this case. So it's.
And Mr. Yes, Your Honor.
So I'm going to adjourn this out to December 11th, 2025, 9 a.m. This time, defendant's bond is revoked.
Drug testing violations are one of the fastest ways to lose judicial trust. Bond conditions are not suggestions, they are contracts. Testing positive for fentanyl, especially while awaiting court proceedings, signals risk not just to the defendant but to public safety and case integrity. Judge Simpson doesn't dramatize this. He doesn't need to. The facts speak loudly. Courts often view substance abuse violations as predictors of future noncompliance. Even if treatment is planned, the violation has already occurred. This is where accountability overrides sympathy. A judge cannot gamble on hope alone. The takeaway here is blunt. Bond is a privilege conditioned on behavior. Break the conditions, and the privilege disappears. This consistency in rulings builds judicial credibility and sends a clear message across the courtroom.
Versus Moses, Hennigan Page.
Assistant Public Defender Jay Bellinger on behalf of Mr. Finnegan Page, Your Honor. Mr. Finnegan Page, can you please state your name for the record?
Moses Finnegan Page.
And Your Honor, we are aware of the violation. I have been able to go over that with my client. My client's willing to speak to that with regard of his willingness to check himself into an inpatient facility or do an outpatient.
Does he admit to the violation?
Yes, sir. If I test today, I'll be clean.
Go ahead, Mr. Bellinger.
Otherwise, Your Honor, we would be asking to, I would be asking to adjourn this matter just a couple weeks so that I can look into a few different things that Mr. Finnegan Page and I discussed.
Probable cause conference will be adjourned to December 23rd, 2025, 9 a.m. October 28th, November 13th, November 24th, you are positive for cocaine.
Yes, sir.
All while you're on bond.
Yes, sir.
Not appropriate. Can't happen. So at this time, you're going to have to figure out some regimen for some treatment because apparently he's not doing it on his own, counsel. So at this point in time, his bond is revoked. Defendant remanded.
Thank you. I will present an order to the court at the appropriate time for hopefully some inpatient treatment.
Court calls the case.
This final segment ties the entire docket together with a clear theme: accountability. Across multiple defendants, Judge Simpson applies the same core principle. Freedom before trial requires demonstrated self-control. Whether it's violence, harassment, or substance abuse, the court repeatedly emphasizes that excuses do not outweigh patterns. Treatment options are acknowledged, but they do not erase violations. That distinction is crucial. The justice system can be rehabilitative, but only when the defendant meets it halfway. In each case today, the court drew a firm line between explanation and justification. The broader implication is this: courts are increasingly intolerant of repeated noncompliance, especially when prior warnings were given. These decisions shape not only individual cases but public trust in the system's ability to protect victims while remaining fair. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.